If you're simply asking the employer to say contest the unit, that's one thing. Here what you're doing is providing information that, to me, the only real value could be to future union organizing efforts for groups of employees that the union is not even seeking in that particular representation case. Finally, and perhaps most important of all, the statement of position requirement, like the 20% rule, will likely defranchise a number of employers from their right to a hearing on whether or not the petition is an appropriate one and contest post-election issues. Within a 7-day period, and perhaps even a shorter period of time, employers are going to be required to basically affirmatively put forward positions which I believe are way too short in terms of time and will end up actually leading to preclusion issues. The final point that I would make in my limited time is the Excelsior Lifts issues, because it's clearly uncertain from the proposed rule as to whether email addresses and phone numbers are work addresses, home numbers. In either case, they're going to represent both property as well as privacy concerns. Very significant. And I would also note as a practical matter that we live in an electronic world. I don't mean to suggest that you can't limit some way from 7 days, but to just go down to 2 because the information's there would be enough. My time is up. Thank you very much, and I appreciate the opportunity to speak.
Thank you. Does anyone have any questions?
This 20% rule, if I understand you correctly, you're saying that relying on a 20% rule would deprive the employer due process or 10C right?
Well, it's a 9. It would be a 9C right.
Excuse me.
It would be a 9C right because the statute talks about a hearing if a question concerning representation exists. Angelica Healthcare is a board case where that issue did come up. It's noted in the proposed rules, and it's distinguished by the majority in the proposed rules. I would argue that I don't agree with that rationale, but the point is, Angelica Healthcare clearly is the case that Member Cohen, actually, I believe, was at that time, former Member Cohen was on the board on. But to me, Member Pierce, I do believe that's a statutory issue over and above the practical one that I raised as well.
Now, if it's 20% or less, and as the current rules stand now, if there is a small percentage that are in issue, the regional director has the discretion to have them vote on the challenge, and if the challenges are determinative, then there's a post-election proceeding, and this process provides similar availability of process in that regard. How does this differ?
Well, first of all, I'm not sure I agree with you that this process so provides. As I noted, you have 2 sections that come out entirely new to us. No dialogue, no discussion. Here we have a proposed rule. One is the 20% rule that says automatically, if I have a unit of 500 and 100 people could be contested, I don't have to have a hearing about those 100 people. That we'll just go ahead, vote them subject to challenge. Now, maybe you do, maybe you don't, because then comes the statement of position. What happens in the statement of position if I didn't mark all these people off? And I didn't say that this 100 group was there. Member Pierce, under my reading of this, I waived that. I'm not sure I get to go back to that. I don't sure what happens in that case, because it's not simply pre-petition. It says at any time you are precluded, if I remember the actual wording in the register. So to me, I think this is part of the serious problem that you have with both of them together interplay, that there's a serious issue. But I'll give you a practical one that I think actually Professor Estreicher noted this morning in his testimony. Why shouldn't a party know who is a supervisor for purposes of an election when you're asking that person to potentially be an agent? What possible reason is there to say that that should not be one of the core issues, that the board should be interested to make sure? There's been enough litigation over the years, including at the Supreme Court, about who's the supervisor. Why wouldn't we want to have those issues decided? And what you're doing is a bright line test, and I understand that. It's a bright line test of 20%. But I think tied together, I'm not sure we do have those rights.
I'm puzzled. I really am, in terms of what you describe as the proposal versus the current practice. One thing the board was clear about, I think, in prior precedent is even if the parties don't wish to defer eligibility issues, there's no right to a decision on those issues, only to litigate.
Right.
In many cases, it's certainly been our experience that when there's a supervisor issue that's disputed and there's a request for review that's granted, there's no decision prior to the election. And of course, if the cases go up to the Court of Appeals, the status remains uncertain. So there's no right currently to a decision on supervisory status
But there's a right to a
prior to
hearing.
the election. So, but how does that, what I'm trying to understand is how does that help the
Because
parties?
it informs the parties. As a practical matter, look, first of all, it's part of, because I didn't get into it, it's my concern about the whole rule because most elections are consent or stip elections in vast majority because parties agree to it. Because we deal with those issues, Member Becker. I'm not arguing about that. What I'm simply saying is this is a bright line test. This isn't an issue of saying, you don't get the hearing, okay? You don't even get the facts out there. You don't let somebody get informed. I know I hopefully am a good enough lawyer and counsel to my clients where I have facts that I didn't know or might come out, that I might have a different view of where things go. And I'd rather know that early rather than late. And I'd rather be able to deal with that early rather than late. I'm not one who's going to say that there's no benefit of that, because I think there is a benefit. And by the way, I think in most cases you're absolutely right. In my own experience after 40-some years, it's absolutely right. We don't have a lot of that. But when we do, I think I've been informed, okay? And I think what I'm simply raising is for the board to consider those issues as you go forward with it. But because what you're simply saying is,
the employer from informing itself. The employer has a question about whether certain individuals are supervisors. As the case law stands now, there's no right to a final decision pre-election.
but there's a right to a hearing.
But how, I'm really struggling to understand how that difference affects the employer's ability to plan and decide who can be used in an election and in what way. The employer can, we're not precluding, if these revisions are adopted, there'd be no preclusion of the employer from conducting any kind of an investigation into the facts that it wishes to.
Look, an employer can conduct any investigation it's wanted. This is a one-way. This is the board saying you don't get a hearing. This is the board saying we're not going to provide you with the opportunity to explore this issue and have the regional director decide the issue. You're absolutely right. The board doesn't have to decide the issue, but you've limited board review anyway. You've eliminated board review at the early stage in this proposal, so there is no board review into this proposal.
But under the current procedure, the board,
But
when
under
it
the
grants
current
review,
procedure,
doesn't
the
issue
board
a
reviews it
decision.
as a request for review.
Correct.
All right? And the board can decide to review it, or it doesn't have to decide to review it. But at least you have that opportunity. You're saying here there is no opportunity. You're saying here it's okay to remove that right. I'm saying I disagree with you.
It's a related question. Again, I'm trying to understand the difference between current practice as you have experienced it and the proposal. In terms of the obligation described in the proposal to, when the unit is contested, the scope of the unit, to make an alternative proposal, it's certainly been my experience that you don't have, under the current practice, a party coming in and simply saying the unit is inappropriate. What the party does is say the unit is inappropriate because it should also include this facility, or it should also include these classifications. That is, from what I see, we're simply codifying what is already current practice.
Let me deal with that, because I think that's a great, because I actually came up at lunch today, because it was a case when I started my career years ago in Chicago, deal directly with this, because then it raises a serious question of how this all would work in that context, okay? Let's assume you have a single unit store, okay? And I'm the employer, and I said, no, I think there are 3 stores, okay? For interchange, personnel, common super, I don't have to explain, all right? So we say that should be the unit, okay? Now, under the proposed notice, as I read them, now, you know, this is just out just a little less than a month, so I'm not as familiar as maybe you are, or I should be, but it's pretty quick to be up here talking about them. But the fact of the matter is that I then say, okay, I think it's a 3-person unit, and let's assume that in my statement of position, I put in 3-store unit rather, okay? And the union still wanted the 1 store, couldn't get agreement, and it's abandoned, okay? And they don't seek the 3-store unit because they don't have showing of interest, or whatever reason, whatever. They then come back with a 3-store unit a little bit later. Am I precluded from now saying, well, maybe it's not a 3-store unit? I now have looked at it more carefully, and it's a 6-store unit or a citywide unit. How does that all work? And why does the employer have to put the most similar unit as distinct? Because I normally, when I did the 3-store unit, didn't think of the most similar to what the unit would be appropriate. I was thinking of what might be the appropriate unit. So how does the most similar rule have any application? Then my final question with respect to that is okay, because I understand what the purpose is, but then it says, employer, you provide all this additional information on this other unit. But why would I provide that information on the other unit when the only question is whether the unit that the union is seeking is most appropriate? It doesn't have to be most appropriate. It's an appropriate unit, I'm sorry. It doesn't have to be the most appropriate under the Act. To do it. That's my concern, Member Becker. That's my concern. And these are real concerns that I have as to how this works, okay? And they're concerns, I understand what you're saying about current law. What I'm simply saying is this changes a lot. This changes the dynamics. This has other consequences to it. And all I would ask the board is to give careful consideration as you go forward with respect to it, because these are significant issues that we have to deal with in terms of it. And I appreciate your time. I'm sorry.
If I could just ask one
Sure.
follow-up question. Let's take the scenario that you're describing. So union petitions for 1 unit. Employer says, I believe that's an inappropriate unit, and the most similar appropriate unit, in my view, would be this unit, which includes these additional facilities or classifications. Wouldn't it help the ensuing discussion in terms of trying to work out that dispute for everybody to know who's working in those classifications?
Look, I think there are vehicles. This goes to a process point. I only wish there had been dialogue in some of this, because I think there are vehicles where it does help. But the point is, helping is one thing. Mandating specific information of the type being asked is more than simply helping to know. Because typically, when in the case that I gave you, which I tried a long time ago, we did present what other classes were there. We had to present, because we were arguing that the unit wasn't appropriate. All of that came out, but that wasn't names and addresses. That wasn't whose these job titles were. That wasn't anything else. That was demonstrating that we thought under board law, the appropriate unit was X rather than Y. That's my point.
Thank you very much.
Thank you very much. I appreciate your time and attention.
Thank you for helping us out. And